Assalamualaikum and hi. And today we will be presenting about legal analysis of marine pollution law in oil spill incident. This is my group mates. So for the introduction, the world ocean is important for global climate regulation, oxygen production, and biodiversity are now facing severe degradation primarily due to human activities. Among these threats, marine pollution, particularly oil spills, stand out as a major environmental challenge with devastating ecological and socio-economic consequences. These spills, whether from operational discharge or catastrophic incident, lead to the significant diversity loss, habitat destruction, and profound disruption to marine ecosystem and coastal communities. So, for many decades, the international community has been developing a complex and evolving set of conventions and protocols to address the considerable environmental problems created by the marine oil pollutions. This legal agreement is represent the foundation for international cooperation, providing obligations for states, obligation for persons, and mechanism for international cooperation in respect of oil spill prevention and response. So this is the several key international convention, which is the International Convention for the Prevention of Pollution from Ship, which is MARPOL. It is one of the most important and widely applied convention. Its Annex 1 sets technical standard for all discharge prevention, required features like segregated ballast tanks and oil water separators. It also mandates real-time incidents reporting to support quick response efforts. MARPOL also evolve regularly to address the new technology and emergency issues. Next is oil pollution preparedness, response and cooperation convention OPRC. It is focused on improving the international response capabilities. State must create national contingency plans, maintain the response equipment, train personnel, and assist other states during the large-scale incident. It also established a framework for interstate assistance for large-scale incidents. The last one is UNCLOS, which is United Nations Convention on the Law of the Sea. It serves as the overarching legal framework. One of the essential obligations under UNCLOS is an obligation for state to protect the and preserve the marine environment and to take measure to prevent, reduce, and control pollution, thus providing an essential spirit of legal basis for all subsequent more specific for environmental agreement. But the next one is the one of the big cases for international response, which is Story Canyon 1967. It's a major oil spill events in the 1967, which is Story Canyon, have been powerful catalyst for international legislation. This particular incident causing widespread contents in the UK and France highlight the uh, significant deficiencies existing maritime law regarding the coastal state intervention and transboundary liability. In response to it, it's directly led to the establishment of the 1969 CLC and 1971 the Fundamental Convention Fund. That's all from me. I will pass it to the next presenter.
So, hi, my name is Nur Fatwa Fatin, and I will be presenting the national legislation, the overview of our relevant national laws. So, Malaysia has established several key national laws and frameworks to regulate and respond to marine oil pollution. First, the Environmental Quality Act that serves as the primary legal instrument for our pollution control. The second one is the Merchant Shipping Ordinance that specifically target the ship-based pollution. The third is the exclusive economic zone that extend the Malaysia jurisdiction for marine pollution enforcement up to 200 nautical miles, aligned with our international standards under UNCLOS. The last one is the National Oil Spill Contingency Plans, or NOSCP, that plays a vital role as the official oil spill response framework, even though the organization is not a national law. It also defines the response levels based on the spill severity, which are the Tier 1 involve the local level response capabilities, Tier 2 requires regional coordination, and the Tier 3 activate the national or even international support. Next slide, please. Okay, so the Malaysia adopts a multi-agency approach to oil spill management coordinated under the National Oil Spill Contingency Plan. The first one is the Department of Environment. It is under the Ministry of Natural Resources, Environment and Climate Change. It also enforced the Environmental Quality Act 1974 that managed license for discharging into Malaysian waters and monitors compliance by industrial and maritime operator. DOE also investigates the oil pollution incidents, conducts site inspection, and may prosecute the offenders in cases of serious environmental violations. In addition, the department also promotes the pollution abatement through policy development, data collection, and public awareness campaigns. Next slide, please. The second one is the Marine Department of Malaysia. The Marine Department enforces the Merchant Shipping Ordinance and ensure adherence to international standards such as MAPOL. It also performs the port state control inspections, monitor for ship source pollution, and has authority to detain vessels that fail to meet its regulatory requirements. The department plays a key role in managing the pollution prevention in Malaysian ports and territorial waters. Next slide, please. The third one is the Malaysia Maritime Enforcement Agency, or known as MMEA. MMEA is the Coast Guard and responsible for patrolling the Malaysian waters, including the exclusive economic zone. It also monitors the illegal discharge and conduct enforcement operations such as vessel boarding, arrest, and investigation. MMEA also works closely with the DOE and the Marine Department in joint response and enforcement activities, acting as a frontline defense against marine pollution. For example, MMEA has launched a search and rescue operation of Johor waters following a collision between the two oil tankers, which named MT Hafnia Nile and MT Ceres 1. So the last one is the Petronas and DORSH. So Petronas, as the national oil company, developed its own internal contingency plans and maintained the oil spill response equipment for its offshore activities. Meanwhile, DORSH is tasked with auditing offshore platforms to ensure compliance with health, safety, and environmental standards, including the preparedness for oil spill incidents. For example, Petronas undertook a new offshore multi-client 2D seismic survey in the northern area of the Malacca Strait to explore and map the hydrocarbon potential in the open blocks of PM 320 and PM 321 of the Langkasuka Basin. So for us to better understanding the Malaysia approach in managing the oil spill incidents, it is insightful to compare it with the leading global example, the United States. In the US, the Oil Pollution Act of 1990, or OPA 1990, was enacted in response to the Exxon Valdez oil spill, one of the worst environmental disasters in the American history. This law introduced a strict polluter liability principle where the responsible parties are held financially and legally accountable regardless of its intent or negligence. So in contrast, Malaysia relies primarily on the Environmental Quality Act 1974 and the Merchant Shipping Ordinance 1952. While these laws form a very legal backbone of all pollution control, they do not yet require any vessel or facility operator to prove the financial responsibility. This is a significant gap in preparedness, especially if the political party cannot afford to cover the cleanup costs. So, the United States also established the All Spill Liability Trust Fund, which provides up to $1 billion per incident for cleanup and compensation, even when the responsible party is unknown or bankrupt. While the Malaysia, however, does not yet have a central compensation fund, meaning the government may initially bear the cost and later attempt to recover it, which is an approach that can be both time-consuming and financially burdensome. So, in terms of enforcement, the US assigned this role to multiple powerful agencies, including the US Coast Guard, EPA, and NOAA, all operating under comprehensive national and regional contingency plans, while Malaysia enforcement is handled by the agency like DOE, Marine Department, and MMEA, which is coordinated through the National Oil Spill Contingency Plan. However, there are occasional coordination challenges and interagency drills are less systematic compared to those in the US. So I will pass this to the next presenter.
So, Assalamualaikum. My name is Anaf. So I will continue for the slide for liability and compensation. So for the legal framework for oil spill liability, managing oil spill incidents also includes assigning liability and securing compensation for any damage, not only using preventive and response methods. Spill of oil often take place on tanker or during offshore work, which causes a lot of damage to the environment, reduces jobs and money in fishing and tourism, and hurt local residents long term. Because of these sequences, we must have a clear legal system that punishes those responsible. Therefore, the rules of liability and compensation in maritime law deter unsafe practices by making the negligent party responsible for what happens, and they allow victims to get the compensation they are own. So in this for the liability compensation, the rules of liability and compensation in maritime law, the main ideas of the regime of the strict liability and the polluter pays doctrine, which are supported by many international agreement and national law. If legal instrument like protocol and conventions did not exist, there will be a great confusing and uncertainties in international oil pollution cases. Given the very complicated system in shipping involving ownership, different countries and regions where activities take place. As a result, it is important to know how this framework functions to improve environmental justice and the rules of the international waters. Next. So to ensure the strict reliability for oil spill incident impacting marine ecosystem. So we have 3 points. So the first one is legal framework for liability management. Comprehensive maritime laws establish framework ensuring parties are held liable for oil spill and enhancing ecosystem protection. So behind the ideas of the polluter pays, based on the rule and strict liability, the polluter pays principle is based on environmental justice and efficiency, the cost of preventing or reducing environmental harm are carried by the polluter. As a result, the person of organization that makes the pollution is held responsible for the cost which act as a deterrent or careless or hazardous action. So the second point is the impact of local communities and ecosystem. So OSP devastated marine environment, affected local economies reliant on fishing and tourism, while harming community livelihood. So for this, the second point, so this is very important in OSP dispute because multiple entities may involve, including the vessel owners, charterers, cargo owners, and flag states. Because of the strict liability, victims need to not worry about meeting strict rules or paying costs in their claims. And the last point is deterrent mechanism against negligence. So liability rules act as deterrents, compiling ship owner and operators to adhere to safety standards, thereby preventing oil spills. So by the law, we can get the ship owner are encouraged by insurance to meet higher safety and operating requirements, which are often required by law. So all these principles combined give international conventions like CLC, they are strong philosophical and legal structure and help they are adopted in national rules by resolving cases of marine pollution. So next. So for the strict liability, polluter pays, economy, we have 3 points. So the first one is economic efficiency and environmental justice. The polluter pays principle ensure that those responsible for pollution bear the financial burden of environmental restorations. The second point is the compulsory insurance requirement for ship owners. Maritime laws mandate ship owners maintain insurance, guaranteeing funds are available for immediate response and compensation. And the last one is enforcement of strict liability standards. Strict liability principles simplify claims processes, ensuring victims receive compensation without proving negligence or wrongdoing. So we can go to the next slides. So relevant conventions. So in this convention, we have two, which is the CLC, Civil Liability Conventions, and we have 5 conventions. So we go for the first one, the 1992 International Convention on Civil Liability and Convention, CLC. So the CLC and Fund Convention work together to handle oil spill compensation. Under the CLC, the ship owner are automatically the responsible for oil pollution damage, even if it not their fault, but only up to a certain limit based on the ship size. They must also have insurance, usually through a protection and indemnity (PNI) club. So for the CLC, if a tanker owner by the ship owner polluted because of the oil spill, the CLC makes the owner liable even without showing it was the owner's mistakes. Yet only up to a particular financial limit that depends on the size of the ship. Ship owners are also required by the convention to have compulsory insurance or security, usually obtained through a protection indemnity. When the ship owner does not or cannot pay or the amount of damage is more than the liability limit, the IOPC fund under the fund convention help with further compensation within determined limits. So next. So for the fund conventions, if the owner can't pay or the damage is more than the limit, so the IOPC fund under the fund convention step into the provide extra compensation. This fund is supported by companies that receive large oil shipments, helping to spread the financial risk with over 120 countries involved. These conventions are key to protect the marine environment, even though there are still some limitations. So, funds convention allows victims to get financial aid regardless of the whether the ship owner is solvent or declare bankrupt. Significantly, the companies that get large shipment of oil by sea contribute to the fund, which means the financial risk is shared by many in the petroleum business. Um, there are still some drawback to the system, but it is the most important legal rules for international pollution damage. So we go to the last part. So for the example case law, I take one of the international cases, industry cases, which is the Erika oil spills. So the Erika oil spill, which happened in December 1990 near Brittany, France, it is an important example on how international rules on liability and compensation are applied in real life. In late 1998, the Maltese flag Total Fina F, which is now called Total Energy, tanker Erika spilled apart in bad weather, releasing more than 20,000 tons of heavy fuel oil into Atlantic Ocean. About 400 kilometers of the French coast were polluted, damaging the local marine life, fishing sector, and tourism. So we get from the Erika oil spills, we can get that the CLC and the fund convention apply in this case because the ship chosen by Total had known issues. A court found the company criminally liable for the oil spill event, though it did not own the vessel. The court stated once again that strict liability exists and the charterers and cargo owners who have a hand in choosing and operating the ship are more responsible. The IOPC fund provided vital support by paying out over 200 million euro in compensation to those affected, which help prove the value of the two-tier liability system. Through the Erika case, the court expanded the rule of liability to include more companies involved in oil transportation, ensuring that ships are handled carefully by all involved. Follow this disaster, the EU introduced rules to screen ships better and phase out bulk carriers that had only one hull. So that's all from me. I will pass to the next presenter.
So my name is Nurari Nabila and I will continue the presentation with the next part, which is future legal perspective. So as incident and law that related to the oil spill develop, certain prominent legal issues are emerging regarding to the technology and regulation in multiple countries. So the first issue is the use of technology during response to the oil spill and in deciding liability. So technology is helping as satellite surveillance, AI and AUVs are now often used for spill detection, supervising cleanup and monitoring. As the result, these new technologies introduce questions that related to the who will hold the responsibility, how used data will be treated in court, and agreement involving data and intellectual property sharing between the contractor and the states. Next. The second issue is issue in cross-border enforcement. Cleaning up after an oil spill often involves more than just only one nation, which can cause complication with the law and compensation. Despite being in the force for over 3 decades, the gaps in enforcement of international environmental agreement, including the Civil Liability Convention and the 1992 Fund Convention, are still caused by issue of overlapping jurisdiction and legal inconsistency. Next. So here are some recommendations for strengthening legal response to the oil spill. The first recommendation is aligning and reconciling international and domestic legal rules. International conventions are not applied in the same way across all countries. While many countries approve OPRC and MAPOL, often their system for enforcement at home are not complete or effective. The second recommendation is technology-related rules at international convention. New technologies in response should be carefully considered by convention, which should also decide minimum technology standard, create rules around using and sharing data, and assign responsibility to data providers. Next. Okay, the third one is establishing a global fund to support countries that affected by the transboundary incident. Systems that used to settle claims are generally not adequate for resolving issues with the cross-border damage among developing or uninvolved countries. Having a global fund run by the UN might increase fairness and hasten the process of recovery after an incident. And the next recommendation is applying climate and biodiversity perspective in decision making. Additional environmental law should call for the recovery of damaged ecosystem, lasting observation, and put this regulation in line with those related to the biodiversity and climate change. Next. And the last one is offering training and enhancing capacity. Various countries have different levels of preparedness, showing that target training, uniform protocol, and simulation exercise will help improve the situation. That's all the presentation from us. Thank you.